Hey everybody, welcome to the live stream tonight. We are covering three really interesting cases. I am going to start tonight with Lori Vallow Daybell. That is a case so strange and so explosive that it has already, not even a trial yet, and it's already spawned two different documentaries. Lori Vallow Daybell is accused of killing her own two children as well as conspiring to kill the wife of her then boyfriend who became her husband just 2 weeks later. There are evil spirits, zombies, you name it. This case has just about every possible element of a criminal case. The trial is in less than 3 weeks, and we are getting ready to cover that in a big way. We are also going to be doing a quick update on the Sam Bankman-Fried FTX case. That is one of history's greatest ever destructions of wealth, according to financial magazines. It's a crypto exchange that crashed and burned last fall, and it's now caught up even Shaquille O'Neal. How? I'm going to explain. And of course, we're going to talk about Alec Murdaugh. We now have the very first rumblings of the appeal. Now, what can we expect? What's going to happen next with the appeal? So let's get started with, and of course, naturally, I have clicked on the wrong button there. Okay, we're going to get started with Lori Vallow Daybell. Now, you may have heard in the news that she was being transferred from Fremont County, where the case has been going and where she's been held, to Ada County, where the trial will be. And you may wonder, why? What is all this moving around? Why has all this happened? And I want to kind of walk you through it. Now, first of all, the court had to actually issue an order, saying we have to move the defendant to where the trial is going to be, because the defendant's in the wrong place. Now, how does that ever happen? And it's not all that close. Take a look. This is the map. Currently, the case has been filed and has been prosecuted in Fremont County. They're going all the way, more than 5 hours, to Ada County to actually try the case. Now, why? Why is it so important that they need a different venue and a different place? Well, here's why. I'm going to take you through one of the most important orders in the case so far and let you take a look at it. Actually, I think I'm going to do it this way because I want you to be able to see this big enough for you to be able to read too. So give me just a second. All right, so let's go up to the top of this case. This is the order that was filed by the court related to where the case was going to be. Oh, just a second. Working on it. Okay. Does that move up and down? It does. Good. We're in the right spot. Okay. So the case has been so sensational, so big, that what the court has had to do is hear motions from the defendants that this is going to bias the local jury against this particular defendant. You may remember that there were issues about that in the Alec Murdaugh trial too, and there was jockeying about where the trial would be. Alec Murdaugh wanted the case where it was, and so did the prosecution, but there were questions about whether or not Colleton County was too small really to field a jury that didn't know the case. But in that particular case, everybody was willing to have it. But in this particular case, and I'll kind of track you through the motion, but the defense was very worried about having the case in the Fremont County area, which is near where the children's bodies were found. And they felt like it would be too prejudicial. So, and this order is really important because it also takes you through some of the jockeying about whether or not Lori Vallow Daybell is mentally competent to stand trial. And the judge talked first about May 25th, 2021, returning an indictment. And before they could even get to arraignment, they've indicted her, they haven't even gotten to arraignment, and the court found her incompetent to stand trial and committed her for some care. That happened not just once, but twice. And meanwhile, there was a motion to change venue. That means to put the case in a different location because the defense said it's just too dangerous for us. risky for us to have the trial here. People are clearly already biased against the defendants. And so that's why we don't want to have it here. So the state at that point filed a motion saying, look, we understand that the defense, and you agree with them, that it would be dangerous maybe to have, or you think it would be dangerous, you judge and the defendant think it would be dangerous to have the case here because the jury may be biased. He said, but look, why don't we just pack up a bunch of jurors from that county over there 5 hours away and pile them into a bus and bring them over here to our county and put them up in a hotel? Because that would be a lot easier than picking up the witnesses, all the prosecutors, the judge, everybody moves from Fremont County to Ada County. I said that it would be a lot easier to do it that way, and cited law that would allow the court to do that, the court is authorized to pick up a jury and move it to another area if that's the best way to get a fair trial, and said it's up to the discretion of the judge. Now that's sort of almost code within the legal community, which means there's not going to be much appeal, that the judge gets to make the decision. It's up to the judge's discretion, and nobody else is going to overlook that or second guess it. There are exceptions, but that means there's a lot of authority given to the judge in that area. So the state went through a bunch of reasons why it might make good sense financially to move an Ada County jury all the way over 5 hours to Fremont. That would be a very unusual thing to do. And I think the judge made a good decision here. If you look down in the footnote down there, you kind of see what the standard is. And the court said, look, there are three things that I'm required to consider. The first is whether or not a fair and impartial jury can be impaneled in this county. The court said, I've already decided, can't do that. Impossible. This is too big a case and too sensational a case and too controversial a case. Cannot get a fair trial right here. So the second two things are whether it would be more economical to transport the jury than to pack up and move to the other location, and whether justice would be served thereby. And they went through the state went through some pretty specific figures, like it would cost this amount. And the state's primary argument was, look, if you're going to sequester the jury anyway, and we'll talk about what that means. If you're going to sequester the jury, why not sequester an Ada County jury in Fremont instead of a Ada County jury in Ada? Either way, you're going to pay for hotel, meals, so you might as well just do it where it's convenient. Now, sequestering. I personally have only had one case ever where the judge sequestered the jury. It's pretty unusual. And in that particular case, the judge did not sequester the jury for the whole trial. The trial was pretty lengthy. The jury was at home, in their homes throughout the trial. And then when it came time for deliberations, as soon as the closing arguments were made and jury instructions were given, from that point on, the jury was sequestered. And so that lasted for several days while they had their deliberations. But there was not a decision in advance that the whole jury would be sequestered the whole time. And that's pretty much what the court said here. The court said, look, I agree that it's going to be expensive to sequester the jury, but this is what I'm thinking, the judge said. I'm thinking that I don't have to sequester the jury for the whole trial. It's going to be, according to what the court has said, 10 weeks long. And the judge said, I don't have to do it the whole time. If I bring an Ada County jury 5 hours over to Fremont, I have to sequester them the whole time. I have to pay for their meals. I have to pay for their hotel. But if what I do is pack everybody up and move over there, I might not have to sequester the jury. And the prosecution went through, here's how much it's going to cost for us to pack up and move over there. Here are the costs that are going to be entailed in moving everything over 5 hours away to this other county. So the court looked at all of that and said, okay, I might not have to sequester the jury. And your figures state only work if I have to pay for the jury, that whole time. And I'm hoping I don't have to. I'm hoping that this is the judge. I'm hoping that there's not so much of a sensation that I feel like I have to sequester them. They can go about their lives. And he made a really interesting point here, because what he said was, look, I also have to consider the most important factor, and that's right here. I've got my cursor on it. And that's that justice will be served. And the court said the most important thing is getting a jury that will be fair and impartial. That's my goal in all of this, and my number one goal. And he said, here's the thing. If I try to get a jury to come all the way over here and be sequestered for 10 solid weeks, I'm not going to be able to pull from a very big pool of people. That is going to be a really small subset of people who could do all that. And so the judge said, look, I think I have a better chance of getting a good cross-section of jurors and a fair, impartial trial if what I do is keep people in their homes as long as possible. And that's my number one goal. He also made a reference, for some of you who will think back and remember the O.J. Simpson trial or maybe heard about it. He made a reference to jury revolt. And that's I had to look it up to try to remember all the details, but there was a period of time that O.J. Simpson jury was sequestered for 3 months. And during the course of that, they became really close to some of the bailiffs who were moving them around, transporting them and so forth. And for some reason, the court removed one or more of the bailiffs who were taking care of them. And they got upset and wouldn't come to court one day. And there was a big hullabaloo with the judge. And that's one of the things that, he was talking about, that would be unacceptable and he would not want that to happen. And so that is the reason that everybody is going to be moving for the 5-hour trek and going over to another county. Now, this trial is going to be public. It's going to be made public, but only by audio and not by the usual video that we've been used to. It's not going to be televised. The court has made a different order in this case and said, okay, you can hear it, but you can't see it. And I think it's hoping that will cut down on interest in the case, that will keep people from being as interested. I don't think it's going to work with this case. It's too sensational, I think, for the court to tamp down on the interest in it. Everybody is going to be interested in this case. It doesn't really matter. But the court has done all kinds of things to try to make sure that there is not a media circus, and has made all kinds of rules, very serious rules about where the media can be. In fact, the media aren't even allowed to have preset tickets. It's a first come, first serve in the overflow rooms and in the courtroom, and there's not a set aside for media to be there. I am sure they immediately started throwing in their, requests as soon as they conceivably could. Now, when the court makes the decision to do that, to keep it just audio, that's controversial. And there has been a lot of pushback from the media wanting to televise it. That's obviously something they want to do. We are on the way to trial. March 27th to 28th, there's going to be a period of time when prospective jurors come to the courthouse and they fill out a jury questionnaire. That is not going to be something that we're even going to get audio for. No one is allowed to see that. And the court said, look, this isn't part of a public trial. This is people filling out a questionnaire. There's going to be part of the jury selection that we'll have access to, but not all of it. And then the trial itself starts on April 3rd. We will definitely be covering that. It's going to be sensational. And I want to take you now to a different case. And I would like to hear in the chat from y'all about whether or not you think that this sounds like it's going to be a really boring case. And I want to persuade you otherwise. This is the FTX case. FTX was a crypto exchange founded by a man named Sam Bankman-Fried, who's known for short as SBF. So FTX, SBF, if you can kind of go with me on the acronyms. And Sam Bankman-Fried you may think, okay, this sounds so boring. It's like bank and money, and how is this really interesting? I am telling you, I really want you to trust me on this one because it's a very crazy case. Sam Bankman-Fried, genius or not a genius, it's hard to even figure that one, but he founded the company, and the officers of the company lived in a polyamorous relationship together in a large multi-million-dollar condo in the Bahamas. Not all of them, but a number of them lived in this condo. And then they used company money to buy multi-million dollar homes in the names of officers, and even in the names of Sam Bankman-Fried's mother and father. They told there's so many little tentacles to this that go out in all directions. They told customers that they would hold that crypto. You give us your crypto and we'll hold it for you. We'll be the holding company for you. But instead, through a back door, according to prosecutors, they lent that crypto to another company that they owned and that then speculated with it and lost it. So the massive loss to the public was huge, a worldwide impact, and $32 billion or more was lost, according to some of the estimates. Sam Bankman-Fried personally went from a $16 billion billionaire to nothing, according to him. There are some questions about that, but that's what he says. They are also accused of massive political contributions that were made using corporate funds and that were made improperly. For example, the allegations are that where the limitation is you can only give X amount in your name, they would give it in someone else's name so that they could really give more. That's what the allegations are. And then to top it all off, the feds were closing in, the FTX itself is going under, and suddenly there was a hack and money just disappeared from FTX. Where'd it go? That was a big question. Tracking suggested it went into an account owned by FTX officers or personnel. All of this is going to be fleshed out in court. Three high-level officers have already pled guilty. It's pulled in also, though, not just the people who were the officers, not just the financial people who were behind FTX. It's also pulled in Tom Brady. It's pulled in Shaquille O'Neal. And we'll talk about what on earth is Shaquille O'Neal doing in the middle of this FTX controversy. So the people who have who have pled guilty already are Gary Wang, the co-founder of FTX, Caroline Ellison, who was the part-time girlfriend of Sam Bankman-Fried, and she was also the CEO of Alameda, which is the company that they own that speculated and lost funds. Nishad Singh has just pled guilty. He was Sam Bankman-Fried's childhood friend and the engineering head, and apparently brilliant at writing code for computers, and may have had something to do with the back door. We will wait and find out. Now, prosecutors, of course, are circling around Sam Bankman-Fried. That's the person they want. They want Sam Bankman-Fried. He's currently on house arrest in his parents' home. He says he's broke. He will definitely be, he is fighting numerous charges. He was able to scrape together $250 million personal recognizance bond from his parents and some family friends. So that's how he's able to stay at his parents' home while he's preparing for his trial. The charges against him are many, and multiple years. He could face 20 years for any of these things. Conspiracy to commit wire fraud on customers of FTX, wire fraud on the customers of FTX, wire fraud on Alameda's lenders, conspiracy on that, conspiracy to commit money laundering. There were also smaller charges like the election fraud, like commodities fraud, like securities fraud. Some of that's been changed in the superseding indictment, and there are some new things. For example, they really fleshed out the contributions, political contributions that were made. He was the second largest donor to the Democrat Party, I read, behind George Soros. So he had many donations he made himself, and then the allegations are that he made some improperly as well. And this is what the allegations are, that he tried to purchase influence over cryptocurrency regulation in Washington, D.C. by steering tens of millions of dollars in illegal campaign contributions to both Democrats and Republicans. So the allegation is he was doing this in order to influence the cryptocurrency regulation. That was why he was doing that. Well, that's the group of people criminally charged. But there are a number of shareholder suits that have been brought, and people are looking around for where are some deep pockets, because FTX is now in bankruptcy, and most of these other people are going to jail. They're turning over their money to the government for whatever that's worth. But that for the question then is, where's the money? And so some of the shareholder suits have gone civilly, this is not criminal, but civilly, against some of the people who were spokespeople for FTX. And that's where Tom Brady and Stephen Curry, Naomi Osaka, and Shaquille O'Neal, they all advertised for FTX. They were all spokespeople for it in advertisements. So at this stage, FTX's involvement civilly has spread out to all of these people who are now being pursued. And I wanted to show you this article because I thought it was really fascinating. According to this, Shaquille O'Neal is in hiding because he's trying to get out of the civil lawsuit related to FTX. Now, remember, this is not criminal. We're not talking about criminal charges for Tom Brady, criminal charges for Shaquille O'Neal, any of that. We're talking about civil charges where they would be asked to pay money to people who were defrauded by FTX. And so that's where Shaquille O'Neal, according to this article, may be hiding out because he's trying to avoid service. Now, what is that talking about, avoid service? Well, when you get sued, you have to actually be given the complaint. There are a couple of ways that could happen. It could be, depending on jurisdictions and so forth, it might be left at your home with an adult or someone authorized to set for you, or it might be handed to you personally. So what he's trying to do is avoid that. We saw that recently when Drake, they attempted to depose the rapper Drake in the XXXTentacion murder trial, and they were never successful. They weren't able to actually find a way to serve him. So this is the case has all the earmarks of the crazy and complex and lots of people being pulled in. And of course, we have our standby interest, Alec Murdaugh, because we have been talking about the Alec Murdaugh case for weeks now. We finally have the notice of appeal. Now, I want to show you, first of all, I want to show you the tweet from Dick Harpootlian. Remember, Lawyer Griffin got in some trouble for tweeting during the trial, but this is past the trial. And Dick Harpootlian said, today, Lawyer Griffin and I filed our notice of appeal for Alec Murdaugh. This is the next step in the legal process to fight for Alec's constitutional right to a fair trial. And I thought you would probably be interested to know, because I think a lot of you will be like, okay, great, an appeal. So what are the grounds? What is it? Let me show you what a notice of appeal is. This right here, that's a notice of appeal. All it says is Richard Alexander Murdaugh appeals his conviction and sentences in the cases referenced above. The sentences were imposed by the Honorable Clifton Newman on March 3rd, 2023. That's it. So if you're hoping for all the details on what exactly they're going to appeal on, what are the grounds, what will they be pushing for, we don't have that yet. All they've done so far is provide notice. We do intend to appeal. That's not really a surprise. We pretty much expected that. We expected that Alec Murdaugh would appeal. But I'll go ahead and speculate with you on, and I'd be interested in your thoughts. What is it you think he's going to appeal on? I would be very interested in what you think about that. But one area, without question, that will be huge is the financial crimes, because the judge let in a lot of information about crimes that were not directly related to the murder of Maggie Murdaugh or Paul Murdaugh. These were financial crimes that Alec, for the most part, has admitted doing, and showed that he stole from clients, he stole from his law partners, from his brother. That was fairly old one and still came in, that he had done a lot of things. There were the reason that the court allowed this information in was that the prosecution said, look, his motive for killing Maggie, his motive for killing Paul, was that he was about to be exposed financially. He was about to come under the gun financially. People were going to learn he had been stealing for years and years and years, more than 10 years. And that as a result, they were going to be looking at him in a new and different way. He wanted to distract from that. And so he killed his wife and son to pull some sympathy onto himself so that people would stop, at least for a time, pursuing him. It didn't work. Within 3 months, he was asked to leave his law firm. He was then a cascade of events happened. He's now been charged with 99 different financial crimes, not just a small number. This is a massive, large amount of crimes. Those will be tried unless there's a plea deal, unless he agrees, pleads guilty, and they figure out a way to move forward in terms of how they will be sentenced. But those crimes are still out there. So his number one go-to appeal is going to be that those crimes should not have been admitted into the criminal trial. Now, that was, at least initially, I think, a pretty good argument. And the reason it was a pretty good argument is because a lot of those were, first of all, I thought that motive was weak. I never thought that motive made a lot of sense. And some of them were pretty far afield. They were crimes, or some of them, like, for example, the stealing from his brother, that was just, he said, oh, sorry, mistake. And no one really seemed to care about that until it came time for trial years later. And so that, because it was not connected in time, I think would be one of the most difficult ones for the state to explain. I think that's the hardest one of all. And some of the others also were fairly far afield in terms of when they had happened. And that would be the primary argument on appeal. But in addition to that, I think that Alec Murdaugh had so much, because he got on the stand, because his credibility one-on-one became such an issue, he put that in issue by going on the stand. I do think that particular appeal ground is going to be more difficult for him, because he got on the stand and the prosecution used that to say, ladies and gentlemen, watch out. We saw some of you, they weren't quite this direct, but we saw some of you crying as he talked about how much he loved Maggie and Paul and said he didn't kill them. But we want you to know, ladies and gentlemen, he's a liar. We want you to know he's lied to lots of people before, and he was persuasive, and that's what he's doing to you here. That was the argument that they made. And so his credibility became all important. And at that point, I think that gives the state an extra argument. Well, he got on the stand and we had the right to impeach him and to show that he lied and could lie to people without them having any idea. So that's what I think will happen when it goes on appeal. I think that gives the state a little more ammunition about why they used that information. I tweeted, and please follow me on Lawyer Lee W. Oh, and as usual, I never said please like the video. Please do like the video. I would appreciate it. It will get it out to more people. And please also subscribe, because I'd love to have you back for more. But I tweeted on, and you can follow me on Twitter at Lawyer Lee W. And I said, look, he's basically got a snowball's chance in hell of winning on an appeal. And that's because the stats are just staggeringly low, below 7% for getting your criminal conviction overturned. So it's really, really difficult. Will he have a better chance than normal? Sure. For one thing, he's got great lawyers, a lot of money behind his ability to bring forward the absolute best appeal. So yeah, absolutely. He will do well, I think, in terms of his appeal. He'll have maybe a better chance, but still, 7%, it's so low. The chances are so low, even with his increased chance based on what he's done. So let me look through real quick any questions that I've missed. Sarah asking, Sarah was asking, wouldn't the appeal be denied because he took the stand and admitted to the multiple financial crimes? I think he would definitely, like I say, I think it will damage it. I don't think it eliminates it, because the fact that they were able to cross him was, and they were entitled to cross him on that because it was already in evidence. But if it had never been in evidence, would they have been entitled to cross him on that? I think that's what his lawyers will argue when they go to the appeal. It looked like in play till it hurts is saying it looked like 2 trials in one. It was 2 trials in one. And that was one of the arguments made by Alec Murdaugh's attorneys. They said, look, you've got one trial over here, which is the murder. That's what we're supposed to be here for. The murders of Maggie and Paul. And you've got another trial over here. And that other trial has to do with all of these financial crimes. And these financial crimes are not connected. So for that reason, Judge, we want you to keep them out because it's going to prejudice the jury. And in fact, it certainly did prejudice the jury in the sense that it convinced the jury that he wasn't someone they could trust. Was that the only reason? No, of course, not, obviously not. But that was one of the things that the prosecution used it for, is to say he's lied to other people. If he can lie to them and fool them, he can lie to you and fool you, so don't believe it. That was their theme in closing argument. And throughout, they constantly were coming back to that. That was one of the most important issues. I think Denise Pelton is asking me if the Sam Bankman-Fried FTX trial will be televised. And the answer would be no, because it's in federal court, which is a shame, because that would be very, very interesting. But no, it will not be. Can insurance companies do anything? This is from Patricia. Do anything to Alec from the frauded cases, from the cases related to his fraud about the insurance? I would say the answer on that is probably no, because he never actually, as I understand it, made a claim against an insurance company. The insurance companies were supposed to, and I think she's talking about the side of the road incident where Alec Murdaugh claimed he was shot in the head, and he did it because he, according to Alec Murdaugh himself, he thought this would allow his son Buster to claim his $12 million life insurance policy, whereas if he killed himself, maybe Buster could not. That is fraud against an insurance company if you try to collect. But since he never actually tried to collect because he never died, I'm guessing it's not an issue from the insurance company, but he is being prosecuted for insurance fraud, which I think would be from the state, but no particular insurance company, since I don't think that there was an actual claim made. We will learn a lot more about that as that case goes forward, and it definitely will, because he's been charged with that. So thanks everybody for watching. We will be back on Friday at 7. We're going to be doing a lot more on Murdaugh, and I will see you on Friday at 7.